everybody else understands who we are. My name is Jerry Sydenham. I'm the legally qualified chair of the panel. My colleagues present with me, ACC Williams, and by Skype, my colleague Yvonne Fisher, who is the independent member of the panel appointed by the Police and Crime Commissioner. Good morning, Yvonne.
Morning.
PC Birkinshaw, can you hear us? PC Birkinshaw, can you hear us? Good morning, PC Birkinshaw, can you hear us?
Yes, good morning, I can hear you.
Excellent, thank you. Just a few opening remarks. You'd be aware, or everybody I hope is aware, that the proceedings are audio recorded. Obviously we're using Skype. This is probably one of the first experiences of that, use of technology to conduct the proceedings. We may, of course, have to go more slowly and accommodate people in different ways, but we will do our utmost and we'll take the proceedings as slowly as is necessary. PC Birkinshaw, this isn't a court of law, it's a misconduct hearing, and the aims of the hearing are twofold. On the one hand, it's important that we are fair to yourself, and on the other hand, we are accountable to the public for what we do within these proceedings. The misconduct hearing is being conducted in accordance with the Police Conduct Regulations 2012, which I'm sure you've discussed with your solicitor and with counsel. The standard of proof will be something which you are perhaps not familiar with. It's different to the standard of proof in criminal proceedings. The standard of proof here for determining whether your conduct has fallen below the requisite standards set out in the standards of professional behaviour is on a balance of probabilities. That's an unvarying standard, essentially whether it's more likely than not. The Police Conduct Amendment Regulations state that these proceedings are to be held in public, and they're being, I understand, streamed to Havertop Police Station. A word in respect of our present circumstances. In the light of the coronavirus pandemic, the proceedings are being remotely accessed by a number of parties. Obviously yourself, PC Birkinshaw, your legal representatives, including your solicitor, Mr. Terry, and counsel, Miss Barlow, counsel for the appropriate officer, I believe your federation representative, and of course, as I've already indicated, my colleague on the panel, Ms. Fisher. All of you are accessing the proceedings remotely. During the hearing, there will be circumstances which probably will arise where we will require the proceedings possibly to be held in public, at least for part of the time, particularly when we may be dealing with sensitive issues. When this arises, the link to the proceedings will terminate, and any parties who need to consult will be able to do so. Additional user groups have been set up to allow the meetings to continue in private. Members of the public, I believe, are also present and viewing through Skype. Can I say at this stage, members of the public also have a responsibility, that is not to interject in the proceedings. They are there to listen and understand the conduct of the proceedings. In respect of any disruption, any persons who disrupt the proceedings will be removed from the proceedings. Finally, I intend to confirm to you that these proceedings are akin to employment proceedings and are conducted, however, in accordance with legislation. They are under a statutory scheme. The principles of fairness and justice will be applied throughout PC Birkinshaw. Did you understand all of that, PC Birkinshaw?
I did, sir. Thank you.
Thank you. Can I now invite all of the other parties who are present, with the exception of the members of the public? So I'm talking about legal representatives, federation representatives, and others who are involved professionally, to identify themselves. Perhaps starting with counsel for the AA.
Sir, this is Aaron Rathmell, counsel for the appropriate authority, presenting the case against the officer.
Thank you, Mr. Rathmell. Counsel for PC Birkinshaw. Ms. Barlow.
So can you hear me now?
I can hear you, yes. Yes, and now we can see you as well. Thank you.
Yes, sir, I'm afraid I'm having to join with an iPad, which isn't ideal because I can only see one party at a time, the speaking party, which is rather unfortunate, but I'm afraid it's the best that I can do. But nevertheless, Sarah Barlow representing the officer.
Thank you, Ms. Barlow. If you need extra time or any other kind of facility that we can afford, please just let us know. If you are in difficulties in understanding who is speaking or there are other communication difficulties, again, please just indicate and we'll try to clarify and accommodate you. I've identified my colleagues on the panel as are present.
Yes, good morning, sir. Andy Farrell, Detective Chief Inspector, Federation Representative for PC Birkinshaw. Excellent.
Thank you all. Having identified ourselves, PC Birkinshaw, I've lost sight of you. I wonder whether you can come back on camera.
My camera's working. It appears to be I can see all of you.
Excellent. Thank you. We can now see you more clearly. PC Birkinshaw, I'm now going to put the allegations made against you to you. I'll go through them slowly. If there's anything you don't understand or need clarification upon or need to consult with your legal representative, we can come out of the public group and allow you to do so. Have you got that? You understood that?
I understand, sir.
Thank you. PC Birkinshaw, it's alleged that in March 2018, Sergeant Piggin and yourself visited a registered sex offender, a Mr. A, at his home address. Mr. A's home address is located very close to a cinema. Mr. A was taken to Huddersfield and was offered support. Mr. A was asked if he would agree to having his photograph taken. It was explained to him that that was for an internal newsletter and a possible future article. You were present throughout and understood that the photograph was not for wider distribution. Mr. A agreed to pose for the photograph with yourself and Sergeant Piggin in the photograph. The photograph itself was never actually used. You showed your then partner, Ms. B, the photograph. You did so in the context of revealing that Mr. A was a registered sex offender. Miss B was aware of this given your role. You had also indicated to Miss B where Mr. A lived and when she commented upon the proximity of the cinema. On the 2nd of May 2019, you were served with a Regulation 15 notice. The notice alleged that it was alleged during your relationship with Miss B, you regularly discussed. In fact, this is not part of the allegation as it's presently drafted. So if you could give me one moment and I'll read you the amended regulation. Understands who we are. My name's Jerry, including your solicitor, Mr. Terry, and counsel, Ms. Barlow.
Can I consult my counsel now, please?
Yes, you can, sir. Certainly.
Sir, I wonder whether I might just clarify. Sir, I think there should be one bundle that runs to 13 pages, and the Regulation 21 notice, the correct version, should have, I think, 7 main paragraphs.
Thank you. Yes, I have that, and it is significantly amended. I'll put the allegation to you as it's correctly framed, PC Birkinshaw.
Sir, I wonder whether...
Sir, could I speak to my counsel, please, after what's just happened, please? I'd like some time to speak to counsel, please.
Of course you can, yes. We will exit the group now and allow you to consult with your counsel. Thank you. Good afternoon. The hearing is resumed. It's 12:45. Ms. Barlow, have you had the opportunity to discuss issues with PC Birkinshaw?
So yes, I have. Thank you. If we might, I wonder whether Mr. Rathmell and myself might make certain inquiries as to the papers that you, the panel, have, just to be sure that everybody is working from the same bundle. I suspect it may be easier for my learned friend Mr. Rathmell to go through this, because obviously it will be the AA from which the documents first emanated. So I don't know whether, I think you should have a 13-page bundle.
Yeah, so I'm happy to assist. It's obviously important that we clarify this for administrative reasons, but also so that the officer knows that what's on the desk and what's in the minds of other participants in the hearing is the same as he's aware of. I was shortly going to send the panel an email along these lines, but I'm happy to make it clear by way of submissions now. I'm instructed that the panel was sent earlier in April the correct bundle, which is 13 pages plus a table of contents, and not any other bundle. But I wonder if the panel can confirm whether they've received any other papers, and then I'll seek to clarify how this matter's come about. The bundle which the panel should have, the 13-page bundle, contains the current Regulation 21 notice, which replaced an earlier version that had more detail about the Reg 15 notice and the original investigation in paragraphs 4 and 5. The error, as I understand it, has come about not because of any fault of the legally qualified chair or because the panel has a longer bundle than the rest of the parties, but because the chair was provided by the Professional Standards Directorate with a form of wording for introducing this public hearing at the commencement of the hearing in standard wording, which had copied and pasted into it the old version of the Reg 21 notice, which had more detail about the Reg 15 notice of investigation that's the backdrop to this case. So that's unfortunate, but again, the panel's invited to confirm what papers they do have, and then I would probably make a submission as to why ultimately this error, such as it is, doesn't matter, but we might clarify what papers we have first.
Certainly, it is correct that we received a bundle consisting of 13 pages with an index. The documents were notice of hearing, case summary, Regulation 22 response, which was added later, statements of PC Barker and PS Piggin, written responses from PC Birkinshaw redacted, and obviously the Regulation 21 document. You are entirely accurate. I was given a document this morning which was addressing really the issue of coronavirus and the way that the proceedings had to be conducted as a consequence of that, and explaining for the benefit of the public and obviously PC Birkinshaw how the proceedings were to be conducted. Ms. Barlow, you're quite welcome to have sight of and a copy of that document if you would like it. You will see highlighted in red on page 1 the reference to the regulations and the coronavirus pandemic. On page 2 of that document, yes, there is reference to, I think from paragraph 4 to paragraph 5, to material that must have been in the original Regulation 15. We haven't seen the Regulation 15, it wasn't part of the bundle, but that is extracted there. So, Mr. Rathmell, you are right in that regard. If that clarifies exactly what we've had. We've had no other material whatsoever over and above in terms of the evidence bundle, those documents, and simply the additional material contained in the note this morning.
Well, sir, it might help then if I make clear, and then Ms. Barlow can respond and make any submission she wishes. The appropriate authority does not allege in this hearing that the officer did commit, in fact, the breach of the standards of professional behaviour which was alleged in the original Regulation 15 notice that was quoted in the original Regulation 21 notice. It was an allegation that the officer may have breached the standards of professional behaviour, which was then to be investigated. And as is apparent from the Regulation 21 notice now, that allegation is not maintained in these proceedings. It's part of the backdrop to the case. So I make crystal clear that the appropriate authority no longer alleges that the officer did breach confidentiality. That's not an allegation which the panel is asked to decide, and I made that point in my written submissions, but it forms part of the backdrop to the present case because the Regulation 21 notice alleges that when the officer received a notice of investigation, he then responded to that by doing something which he shouldn't have. That's the point of this case. And so it follows in my submission that there's no prejudice to the officer in these proceedings to the panel having slightly more detail about that background Regulation 15 notice and the background investigation, because it was merely an allegation, and this is a professional panel which can make the distinction between an allegation and a fact or a dispute which they have to decide, and that's something that's canvassed in a number of cases. Of course, there'll be no suggestion of irredeemable prejudice or bias, not reasonably in any event. Whilst this sort of administrative error is unfortunate and tends to arise when things are done just a little bit differently, as is the case at this hearing, it's not one which causes the officer any real prejudice, and the right thing to do now would be to read the correct Regulation 21 notice, have the response of the officer, and then proceed to hear submissions. But I'm in your hands, sir.
Thank you, Mr. Raffnell. Ms. Barlow.
Sir, thank you. Could I make it clear from the outset that on behalf of the officer, there is no application that the panel recuse itself? I make that very plain. The officer is fully aware and completely understands, sir, that you are a professional panel and more than capable of putting aside anything that may be prejudicial, and of course separating, as it were, fact from background. So, sir, I make no application in that regard. Of course, the officer is concerned that material has come before you that shouldn't have done. That is unfortunate, but it is right to say that my only recourse would be to make an application that you recuse yourselves, and I do not do that. But nevertheless, it's perhaps understandable that the officer was concerned about that. Perhaps more importantly, sir, because of course these are public proceedings, and he did not anticipate that things that he was not facing, not accused of at this point or in this hearing were in the public domain. But sir, I'm sure that of course nothing would be reported that would be inaccurate insofar as that which the officer faces. And the appropriate authority have made it very plain that he does not face the allegations that were contained in the original Regulation 15 notice.
That is absolutely correct, and yes, there is a responsibility to accurately record what the allegations are and what the response to those allegations are. As part of the existing Regulation 21, there is a reference at paragraph 4 of the background circumstances, which is simply put, on the 19th of March, your then partner alleged that you had shown her the photograph. That is not part of what we are considering today. It doesn't form the basis of the allegation at all. In fact, our assumption is, as it's not being referred to at all, that there is no evidence to support that allegation, if it was an allegation as framed. That issue is largely immaterial to the allegations which have been framed in the Regulation 21. It is correct that we are a professional panel and we are able to put to one side material which is inadmissible, irrelevant and prejudicial. In fact, we actually haven't received any material in the bundle or elsewhere. As I've indicated, the document which I was given this morning, Ms. Barlow, will be can be sent over to you to look at. I think it's now appropriate that we proceed with the allegation as framed in the Regulation 21, and I can't actually see PC Birkinshaw other than a small picture below, but I'm assuming, PC Birkinshaw, that you can hear.
Yeah, I should be going live there to you, sir. I can see you.
Excellent.
Can you see me now?
Yes, we can. Thank you very much. PC Birkinshaw, the allegation is that at or about 1300 hours on the 2nd of May 2019, you visited PC Sarah Barker at her home address, that you told her about the notice that you'd received and showed her the notice and associated paperwork. You explained that it related to an incident when a Miss B alleged that you had shown her a photograph. You told PC Barker that you wanted her to contact Sergeant Piggin or you wanted her to tell him to delete the photograph from his phone or she should tell him to do this directly, by which is meant face-to-face and not via a telephone or a message. It suggested that by doing so, you intended to disrupt and potentially undermine the investigation which was being conducted into yourself. As a result of those actions, it's alleged that you've breached the standards of professional behaviour, in particular the standards relating to honesty and integrity, in that you failed to act honestly and with integrity, as I've referred to, which is actually paragraph 7 of the Regulation 21 notice, which I'm sure you will have seen, and that your conduct was discreditable conduct, that your conduct discredited the police service and or undermined public confidence in it. It's also suggested that those matters, individually and or collectively, amount to gross misconduct. Namely, that's a breach of the standards of professional behaviour that, if it were to be proven against you, is so serious that your dismissal would be justified. Can you indicate whether you admit or deny the allegations as they are put? PC Bertram.
I admit the facts as alleged in paragraph 1 to 7, A, B and C. I do not accept that I intended to undermine or disrupt the investigation into myself. And finally, I accept discreditable conduct, but I believe my conduct amounts to misconduct and not gross misconduct.
Excellent. You've set that position out with clarity. Thank you, PC Birkinshaw. That was our understanding of the point that we had reached, and Ms. Barlow, that you can confirm that is the position.
Sir, I can. It means that the issues are extremely limited. It's the intent point and then an assessment really of what the conduct is to.
Thank you. Mr. Rathmell, would you like now to proceed with your opening note and presentation of the case?
Certainly, sir. Thank you. Before I do, can I just clarify or add to Ms. Barlow's characterisation of the issues? Firstly, there's a difference between the parties as to whether the admitted conduct amounts to misconduct or gross misconduct. That, I think, is uncontroversial. But do I I understand it correctly from the officer's response to the charges just now, where he admitted that the standard of discreditable conduct was engaged and didn't expressly admit honesty and integrity. Is there also a remaining dispute as to whether the conduct, admitted or proved, engages the standard of professional behaviour in the regulations known as honesty and integrity?
I can confirm, sir, there is an outstanding issue as to whether it would amount to, in particular, dishonesty. I think there's potentially a crossover between the definition of integrity and discreditable conduct in any event. Clearly, integrity being described as doing the right thing. That is something that I confess that I have not specifically taken instructions from the officer on, but clearly as he accepts discreditable conduct, then that there would, I think, as a matter of law, be that crossover. But the concept of dishonesty is very clearly an issue between us. I hope it assists.
That does assist. That was my understanding of the position as reached, Mr. Rathmell, and I think you have to proceed on the basis that dishonesty, as it were, is denied, and integrity is at play as well.
Understood, sir. Thank you. In which case, can I open the appropriate authorities submissions in this way? The key paragraph in the Regulation 21 notice, which I want to focus attention on, is paragraph 7. That's the allegation that the officer, having received the Reg 15 notice that he was under a formal investigation, then contacted his friend, P.C. Barker, said to P.C. Barker that he wanted her to contact Sergeant Piggin, who was involved indirectly in the matters that were now going to be under investigation. The officer, P.C. Birkinshaw, asked Ms. Barker, or said that he wanted her to tell Sergeant Piggin to delete the photograph from his phone, and that she should do this directly, as in face-to-face, and not via telephone or message. And I can be very brief in my analysis of the facts, because the witness evidence is not in dispute. Page 1 of P.C. Barker's witness statement of May 2019, in the middle, says this: Chris then told me that Chris being P.C. Birkinshaw, P.C. Birkinshaw then told me that he wanted me to contact Sergeant Piggin and tell him, and I underline this, sir, that he needed to delete the photograph from his phone. He told me that I shouldn't phone him or message him, but speak to him directly. And of course, that statement goes on to say that having heard this from P.C. Birkinshaw, P.C. Barker, of course, did not do as the officer was suggesting, did not contact Piggin, did not tell him he needed to delete the photograph, but instead P.C. Barker did what the appropriate authority submits was obviously the right thing to do, and that's to contact the Professional Standards Directorate and to raise a concern about P.C. Birkinshaw's conduct, all police officers, of course, being under the obligation to challenge and report what they consider to be improper professional behaviour. You have, sir, the written opening note that I sent to the panel this morning. That's 16 pages. I wonder if, amongst all the technical difficulties, you've had time to read that note.
We have had time to read it. I think it would, however, assist for everybody in understanding the proceedings if perhaps you took us through it. Maybe not word for word, but perhaps to indicate the points you make in respect of the law, which is important, and Ms. Barlow may want to respond to those, and some of the factual issues which you've already touched upon. That's also important for PC Birkinshaw to understand. I'm not sure whether he has had the opportunity to see your opening note and whether it's been explained to him. You're nodding, Ms. Barlow, I suspect.
So no, I'm afraid I haven't had that opportunity. The fault is mine. I was too busy being distracted by technology as opposed to forwarding that to the office, which I should have done. My learner friend
I think it was also forwarded to PC Birkinshaw's solicitor. But, if he hasn't read the notice, albeit that his two legal representatives have, he's certainly welcome to. It's a document in this case.
Yeah.
Thank you. If you could take us through it and highlight the important points. Obviously, the content is relevant throughout, but there are certain, I think, issues that need to be made clear to the officer in terms of both the law as you are advancing it and the facts which substantiate the allegation in terms of gross misconduct particularly.
Indeed. Well, I'll start at paragraph 4, where I outline some, as I understand it, agreed background facts. And the facts are these. The officer was in a relationship with a lady who's referred in these proceedings to as Ms. B. That relationship was between approximately September 2017 and October 2018. The relationship became toxic. Those are that's the officer's phrase used in the Regulation 22 notice, and began to break down in April 2018, ending in October 2018. There then follows what is and should be a private matter for the officer, but he was away from work for a time after the relationship broke down because of how the relationship affected him in part. Thereafter, the officer and Ms. B made cross allegations where they effectively reported each other to police or to their employers, which were then investigated, but nothing, and I make this clear, was referred to CPS in relation to either party. The officer then obtained what's known as a non-molestation order or no contact order, which prohibited Ms. B from contacting him. That order was made on the 15th of May 2019, although I make clear that the order was made in the absence of Ms. B, and the judge who made the order also made clear that he made no findings of fact as to the dispute between Ms. B and the officer. But it's clear that there was something of a restraining order in place from that point, and so contact ceased. The Regulation 21 notice, which is the document that charges the officer with allegations to be decided in this hearing, refers in paragraphs 3 and 4 to the officer being served with a separate type of regulatory notice, the Reg 15. That was in May. That alleged that the officer may have breached the standards, but again, that's background only in respect of a disclosure and confidentiality matter. That allegation is no longer pursued by the appropriate authority and not to be decided by this panel. So then in the opening written submissions of the appropriate authority, I outlined some of the case law regarding hearsay evidence and the circumstances in which an officer does not give evidence in their own case. Not especially important in this case, and I'll skip over that for present purposes. What is important is the primary purpose of police misconduct proceedings, and that is to protect public confidence in the police service. And I cite the case of Green in the House of Lords in particular, which said that public confidence is a factor of great importance in the maintenance of law and order. If citizens feel that improper behaviour on the part of police officers is left unchecked and they are not held accountable in a suitable manner, that confidence will be eroded. The second purpose is a declaratory purpose, maintaining high professional standards. And the third purpose is to protect the public and protect fellow police officers and staff from preventing an officer effectively offending again. You'll see in the opening written submission, sir, I cite a range of case law in the High Court and Court of Appeal concerning the disciplinary standards for solicitors and for police officers, because the case law is usually treated as analogous. Particularly important in this case is a Court of Appeal case known as Salter, and I refer to that at paragraph 12 of the written submissions and also at the end of the written submissions. The other case, one of two further cases I wish to highlight, is Bolton and the Law Society. In that case, Lord Bingham explained the purpose of disciplinary proceedings against solicitors, and I put in brackets also police officers, and the apparent harshness of the standards and the sanctions that are sometimes imposed on police officers. Lord Bingham also said in that case that it often happens that a solicitor appearing before a tribunal, a disciplinary tribunal, can adduce a wealth of glowing tributes or professional references from colleagues and members of the community, and can often demonstrate that losing one's job would be tragic if that were to be the result of misconduct proceedings. Lord Bingham said all those matters are relevant and should be considered by a misconduct panel, but that none of them touches on the essential issue, and that's the need to maintain among members of the public a well-founded confidence that any solicitor, and again I put in brackets police officer, will be a person of unquestionable integrity, probity, and trustworthiness. And so that case was applied in the case of Salter, and for shorthand I refer in my written submissions, paragraph 17, to the Salter principle, that personal mitigation carries little weight. That's especially and obviously so in honesty and integrity cases, but the more recent case of Williams also makes clear that it applies to all the other standards of professional behaviour as well when they're breached. And in the present case, that relevantly includes the standard of discreditable conduct. So in light of the limited admission made by the officer in this case in relation to the honesty and integrity breach alleged by the appropriate authority, can I highlight to the panel paragraph 18 of my opening note, and that's the case of Wingate. That contains a lengthy discussion of the difference between honesty and dishonesty on the one hand and the lack in integrity on the other. They're related but not identical concepts in professional disciplinary proceedings. The test for dishonesty is the test in Ivy and Genting, and I'll send that to the panel separately. Integrity will take centre stage in these proceedings, and the Court of Appeal in Wingate held that integrity connotes an adherence to the ethical standards of one's own profession, and that involves more than mere honesty. The duty to act with integrity applies not only to what professional persons say, but also what they do. So if I can jump around in the written submissions to a passage in the College of Policing's guidance on outcome, which wouldn't usually feature in opening submissions, but in this case, at least misconduct is admitted. So there can't be any objection to me referring to outcome in the opening submissions, because the panel will have to consider at least the appropriate outcome in respect of the misconduct admitted. But paragraph 35 of my opening submission, I refer to the College of Policing's guidance, paragraph 4.27, and I extracted this quote because this case is about honesty and integrity in connection with an investigation, just as the Salter case was. So the panel's going to derive assistance in this case chiefly in my submission from the case of Salter itself, and from the standard of honesty and integrity and what the guidance on outcomes from the College of Policing says about that. But paragraph 427 states, impropriety involving corruption, deliberately misleading or compromising an investigation, or willfully failing to give proper disclosure in a criminal prosecution is likely to be comparably serious to and/or involve operational dishonesty. Other examples of operational dishonesty might involve tampering with evidence, interfering with witnesses, or disclosing information held by police for financial gain. And the appropriate authority submits that part of that passage, not the reference to corruption and criminal prosecutions, but the remainder of that passage is relevant in this case because what the officer did, what he said to PC Barker, was in effect to seek to contact a potential witness or a potential person of interest to an investigation that PC Birkinshaw was the subject of, get a message to him, effectively behind the back of the Professional Standards Department, and tell him that he, quote, needed to delete a photograph. Hence, what might otherwise appear to be a rather high-level allegation, tampering with evidence, interfering with witnesses, is regrettably a live issue in this case. That is what the officer did. He got served with a notice of investigation. He immediately went about trying to get a message discreetly to a potential person of interest in that investigation, and that message was to delete relevant evidence. The panel will, of course, note that the bundle is brief in this case, and there won't be live witnesses, and therefore this may not be the most dramatic or exciting hearing, certainly not to watch. But that is because the conduct is clear-cut, is substantially admitted, and sometimes panels have to call a spade a spade. And that's why the appropriate authority submits that this is a case of dishonesty and lapse of integrity, not just simply failing to do the right thing, but actively trying to get a message to a witness or a person of interest in an investigation and tell them to delete something that was potentially relevant to that investigation. So I won't rehearse the procedure because this experienced misconduct panel will be familiar with it. That dealt with it, paragraph 20 of my opening note and following. But the submissions on the facts at paragraph 28 and following in my written submissions, I would ask the panel to reread. I've taken the panel to the key passage of the Regulation 21 notice and also to what the appropriate authority says is the key passage in PC Barker's witness statement, so I won't repeat those up either. But I do make the following submissions briefly. It's to the officer's credit that he has now admitted that PC Barker's statement about what he told her, what he asked her to do, is accurate. That statement's not challenged. But it should be noted that this isn't an early admission as defendants say in criminal proceedings sometimes get the full credit for, because from the outset of this investigation, the officer did not admit that he had told PC Barker to delete, to get a message to Sergeant Piggin to delete the photograph. And the officer must have known that that was the centrally important allegation in this case. He didn't admit it until recently. In fact, he said in his statement to the investigator that he had indicated to PC Barker that she could tell Sergeant Piggin about the investigation but that he didn't say anything about deleting. As he said in his Regulation 22 notice, still, PC Barker must have been mistaken about that. She must have misunderstood him. That's now fallen away. PC Barker's evidence is admitted. But it's odd and worrying. The panel might think that the officer positively stated in the investigation to the investigator that his version of events regarding the conversation with PC Barker was as far as the conversation went, and quotes, nothing else was mentioned. Not even the officer admits that statement was, not even the officer maintains that contention which the officer made to the investigation is true. That is surely a matter of concern. The officer would have known when he was served with the Regulation 15 notice whether it was the most serious type of investigation or not. The fact of service of a Regulation 15 notice, the fact of having to be visited by the Professional Standards Directorate was something potentially serious. He must have been nervous. And it was immediately after he was served with the Regulation 15 notice, which referred to confidential information and its disclosure, something which everyone knows the police service takes very seriously, especially nowadays. The officer must have known that this was developing into a potentially serious matter. And yet, in his responses to the investigator for the purposes of the investigation for these proceedings, PC Birkinshaw tried to downplay that he had any personal motive for trying to get a message to Sergeant Piggin, especially to delete the photo. PC Birkinshaw said this to the investigator: "I had no issues regarding the photo. I didn't take it, but I was concerned for Sergeant Piggin." And the appropriate authority submits that appears to be disingenuous, because the investigation was not about taking a photo. It was about PC Birkinshaw disclosing the identity of a rehabilitating offender for non-policing purposes, and it was PC Birkinshaw who was under investigation, not Sergeant Piggin. PC Birkinshaw may well have cared about Sergeant Piggin. He may want to have not involved him or even protect him from the fuss and potential discredit of an investigation arising from the breakup with his ex-girlfriend, of a relationship which PC Birkinshaw himself describes as a toxic relationship. But firstly, can the panel really credit PC Birkinshaw's insistence in his written accounts to the investigator that his motives were purely to protect Sergeant Piggin? Is it credible that PC Birkinshaw was not trying to get a message to Sergeant Piggin for his own self-interest at all? And the appropriate authority submits that it's obvious that PC Birkinshaw was seeking to protect himself or acting in his own self-interest in some way, and that's why he went with haste, not through official channels, not through the Federation, but to a trusted mutual friend to get a message to Sergeant Piggin, specifically that he needed to delete a photograph. Obviously relevant evidence. But even if PC Birkinshaw was entirely benevolent in trying to get a message to Sergeant Piggin, that well-meaning interference would still amount to gross misconduct. And that's because PC Birkinshaw was an experienced officer. I'll be corrected if I'm wrong, but of some 15 years service, and he plainly understood that a Regulation 15 notice of the commencement of investigation, which referred to a photograph, the photograph would be relevant evidence. Yet that's the very evidence that PC Birkinshaw tried to put out the message needed to be deleted. There's also something unedifying in PC Birkinshaw's styling in his response, in his written accounts in the bundle, his visit to PC Barker as, quotes, a welfare check for her benefit, in other words. when that visit took place immediately after PC Birkinshaw had been served with the Regulation 15 investigation notice, when he was upset, when he was worried and nervous, and it was PC Birkinshaw who requested to see PC Barker, not, it's plain from her statement, the other way round. PC Birkinshaw then got out his investigation papers, discussed an investigation with PC Barker, not with his police friend, not with any lawyer who may be instructed by the Federation, but with a mutual friend, and tried to get the message out to a person of interest to the investigation. So it's obvious, and regrettably, the appropriate authority submits that the officer's responses, his written accounts in the bundle before the panel, are not frank accounts as to his motive, as to what he said even. And even the officer acknowledges that to some degree now, having admitted that PC Barker was not mistaken in her evidence. She was correct, she did the right thing, and that it's the officer who committed at least misconduct. And as to motive, it's relevant in my submission that it would be entirely rational for PC Birkinshaw to attempt to reduce the chances that he or Sergeant Picken would be in trouble because of the existence of some photo that may or may not have been disclosed. That's what the investigation was about. The reality is that some people who are the subject of disciplinary or police investigations do attempt to destroy evidence or delete evidence, electronic or otherwise. They do attempt to contact potential witnesses first before investigators do, directly or indirectly. Indirectly, all the better, because perhaps no one will find out about it. And this might be for a range of reasons. And that's why some investigations are covert or conducted by surprise. So it's rational. Someone's trying to get themselves out of trouble. But the point in this case is that for a police officer to do so is obviously grossly improper. And investigations are a core business of policing. It's a key function of the police. So for an officer to try to get to a witness, to try to get a message out that evidence needed to be deleted, it is grossly improper. Paragraph 40 of my written opening submission simply highlights that PC Birkinshaw's personal mitigation, I refer back to the case of Bolton and the Law Society, the comments of Lord Justice Bingham. Of course, personal mitigation is relevant. The panel will have to assess how relevant. Does it explain the conduct? Did the officer act in a particular way because of a particular element that features in their personal mitigation? Or is it simply designed to highlight the effect of a potentially adverse outcome on an officer and then make the panel think twice before reaching that outcome? The relevance and the probative value of the personal mitigation is a matter for the panel. But again, referring back to the Salter principle, the appropriate authority submits that personal mitigation carries little weight in these proceedings because the primary purpose is to vindicate public confidence that police officers act with integrity, especially in relation to investigations. And I emphasise in paragraph 40 of the written submissions that this is not a case where PC Birkinshaw had no support and had no one to turn to, no options available to him other than to go and seek out PC Barker. Quite the opposite. He was served a Regulation 15 notice and supported by the police federation. He could have spoken to a federation officer, a police friend, a lawyer in due course, or he could have simply kept silent. If he had any health concerns, he could have gone to occupational health and so on. What the officer did was precisely the wrong thing to do, and he has no one to blame for that but himself. This is not a case about a heat-of-the-moment decision. The officer did not blurt out something he shouldn't have. He didn't make one silly decision. He read, rather, the investigation notice. He decided to contact P.C. Barker, someone he trusted, someone who, not coincidentally, is a mutual friend between him and Sergeant Piggin. He visited P.C. Barker. He discussed the investigation with her, and he asked her to do something, contact Sergeant Piggin, tell him that he needed to delete the photograph. The officer asked P.C. Barker to do something which he knew, he must have known, was inappropriate. Perhaps that's why he was doing it in such a discreet way. And this case, for those reasons, is comparable to the important case in these sorts of proceedings of Salter, and I explain why in paragraphs 42 and 43 of my written submissions. The motive of the officer who destroyed evidence in the Salter case was undoubtedly benevolent, as the High Court recognised the sergeant had nothing personal to gain by destroying evidence. The reason why the officer in the Salter case destroyed evidence was because of a misplaced sense of loyalty to his colleague and a concern that his colleague's family might be hurt by the evidence, which wasn't particularly relevant to the investigation that was in issue in any event. But the essential point repeatedly emphasised in the High Court and Court of Appeal in the Salter case was that the sergeant's actions interfering with an investigation were inimical to the office of constable. Investigations are, as the public rightly appreciates, a basic and important function of the police. Officers are inherently likely to become involved in legal proceedings. They're part of, in the vernacular, the chain of evidence in criminal investigations. Officers' disciplinary histories fall to be disclosed in legal proceedings, including criminal proceedings when relevant. A finding of breach of the standards of honesty and integrity and or discreditable conduct in the context of an investigation may be particularly relevant where, for instance, in criminal proceedings in the future, an officer's credibility is an issue. Have they handled evidence in that future investigation appropriately, with integrity and so on? Their misconduct history will obviously become relevant then. And the concern is not with the officer's abilities, but with a proven lack of integrity. So the panel will, in my submission, find the Salter cases particularly important because they're factually relevant and similar. It's a case of breach of the standards in the context of an investigation, but also because of the implications discussed in Salter of a finding of a lack of honesty and integrity. Finally, and I'll finish in just a moment, to summarise, P.C. Birkinshaw sought out a trusted friend, P.C. Barker, and asked her to get a message out to delete something which P.C. Birkinshaw knew to be relevant to an investigation. That put P.C. Barker, it shouldn't be forgotten, in a very difficult position. She refers to being distressed in her witness statement. But crucially also, P.C. Birkinshaw's conduct risks undermining the reputation of himself, his force and police generally, because it was simply the exact wrong thing to do in response to an investigation. And it is so vital that the public has and maintains confidence that officers will be held to account for their conduct through investigations and through misconduct proceedings, and crucially they'll behave responsibly when they're served notice of an investigation. So those are the submissions that I make at this stage. It probably doesn't assist the panel to have junior counsel repeating the facts in a relatively brief bundle. So you have the factual evidence, you have the appropriate authorities' submissions on the law and why the conduct alleged amounts to gross misconduct. I can send you any of the case law authorities which I've referred to in my submissions, perhaps in the lunch break, but I'm also happy to assist with any questions the panel may have for me.
Thank you, Mr. Rathmell. Do you have any questions?
No, I've read it all.
Mrs. Fisher, do you have any questions as a result of the address?
Sorry, no, I have no questions. Thank you.
It's a little formalistic on my part, but that is the appropriate authority's case. There's no witnesses to be called because no evidence was challenged.
Thank you, Mr. Rathmell. It's now 1:35. Ms. Barlow, I think you need both a lunch break, as does PC Birkinshaw, and also the opportunity to discuss with PC Birkinshaw what the AA's case is, what the law is, what points you may have in response, in addition to the material you no doubt already wanted to present. How long do you think, including a break, an appropriate break for lunch, you'd require to do that?
So ordinarily I'd say an hour, but I am very conscious of this particular medium does take longer to work with, even if it's only connecting up. So I wonder whether I might ask for perhaps a little longer than that. Could I inquire as to whether you received the folder of character evidence? Yes.
Yes, we did. Thank you.
Thank you. I don't know that there was also the non-molestation order, which I didn't attach. In fact, within that, I don't know whether you would like me to forward that. My learned friend very kindly supplied a copy that was an awful lot better than mine. Mine was a photograph of the order.
Perhaps we can have that. If that could be emailed across, that would be of assistance as well. Email to PSD, I think. To you.
So in that case, I think that is where I got it from, and it was sent on to me from there. So it may be easier if it simply is forwarded to yourselves.
Excellent, thank you. An hour and a half, and you can give us an indication, or give Mr. Rathmell and PSD an indication. If you need any longer than that, please do. We appreciate, obviously, and PC Birkinshaw will appreciate these are serious matters and you need proper time. And given the circumstances that we're in, communication is much more difficult than it normally would be. So please take your time, ensure you cover all of the points that you want to cover as thoroughly as possible. Thank you.
So I'm grateful. Thank you.
Thank you. Thank you. We're ready to resume the hearing now. Just want to check that we are actually recording again. Thank you. It's now 15:19. Ms. Barlow, we don't have you in view.
She'll come in view whenever she's about to speak.
Can you? Thank you. I can see Officer Birkinshaw. I can see our colleague Yvonne Fisher. We're simply waiting for Ms. Barlow to appear.
Sir, I hope you can hear me. I should be there.
We can hear you and we can now see you as well. Thank you. Thank you. I was just saying it's now actually 15:20. Would you like to present your case on behalf of Officer Birkinshaw, please?
So yes, of course. So can I say from the outset that I will possibly be almost by definition briefer in my submissions than those of the appropriate authority. Of course, one might expect that because, of course, the appropriate authority have to set out their entire case and quite rightly refer to outcome at this stage. Of course, I'm sure it will be moved on to at a later stage as well. But of course, one has to separate out in my submission questions of the ultimate outcome. We will inevitably move to that in this case, of course. But from the questions of findings of fact and whether, dependent upon the findings that you make, the conduct amounts to misconduct or gross misconduct. And so, obviously, being guided, of course, by yourself, I would at this stage, unless you wish me to go further than that, confine my submissions to the findings of fact and the question of what the conduct found would amount to.
Thank you. Yes, I think there were three main points of focus. One being whether PC Birkinshaw intended to disrupt or potentially undermine the investigation, and factual issues around that. Obviously, the honesty and integrity allegation and any findings of fact around that, any comments you wish to make, and yes, of course, whether the conduct, if we find conduct proven, amounts to misconduct or gross misconduct. Yes.
Yes. So, of course, the officer does accept, and it's clear from the Regulation 22 notice, that conduct would amount to discreditable conduct. But so perhaps I'll expand upon that later if I might. So perhaps from the outset I should say that I take no issue with the legal principles as outlined by the appropriate authority. In due course, there is a further authority which may assist, which is of course the case of Knowles, which I can forward the reference in due course. That is, as are the cases of Bolton and Salter, and under the similar authorities, if I can put them under that umbrella. They really deal with questions of sanction or outcome. They do mention sanction, of course, that's the old-fashioned word for it. But so could I say from the outset that whilst, of course, I do accept entirely the legal principles outlined in those cases, they are cases that very much focus upon outcome and not upon findings of fact or the assessment of seriousness. They do, of course, there is a crossover, I do accept, but it was very much focused entirely upon outcome. They cannot, in my submission, guide you in relation to findings of fact that you will ultimately make. So I say that, of course, because they were cases in which it was the argument, as it were, before the court was what the appropriate outcome was in respect of findings that had been made, in respect of dishonesty, i.e. dishonesty had been found, and therefore what the appropriate sanction was. So, as I say, they are interlinked, but perhaps the primary question you may feel for yourselves is that question of what the officer's intention was. And in relation to that, I would certainly ask the Regulation 21 allegation is, of course, the allegation that the officer faces and that which you have to make a decision upon. And the disputed part of that allegation, the part issue, are those words that by doing so, you disrupt and potentially undermine the investigation into yourself. It's right to say that the officer does accept the factual basis, namely that he asked PCB that you wanted her to contact Sergeant Piggin, you wanted her to tell him to delete the photograph from his phone, and she could speak to Sergeant Piggin face to face, not by telephone message. So, of course, I would urge caution perhaps in one respect, and it is this. The officer does accept the evidence of Barker. He does not and would not suggest that she was in any way fabricating her evidence. It is, of course, his case that she made an assumption, and an inaccurate one, as to what she was being asked to do, i.e. she misinterpreted his intention. But he does not seek to suggest that she is in any way being untruthful in her evidence, hence being not challenged. But so that having been said, of course, it is important to note that that is him accepting her word for what happened, as opposed to him putting forward any direct conversation himself, something which he has, I don't think, ever professed to do in the sort of detail which she recounted. So perhaps when looking at the intention of the officer, there are perhaps broader considerations, and it may be of assistance to start with the character reference that you have. So this is where there is less of a crossover, if I might put it this way, between the character references as relevant to outcome, as referred to in the cases of Salter, etc., and character references when one is assessing the credibility of the officer, which is, of course, a necessary part of the function that you are about to embark upon, i.e. in deciding as to what his intention was at the time. In my submission, there is nothing, of course, to prevent you from looking at those character references to make an assessment of the character of the officer, i.e., by inference, what is he more or less likely to have done. So the character references are numerous, and they do come from some senior officers who have been directly responsible and for the management of and worked with over the years. And perhaps a good starting point is the older references, i.e. those that refer to a period of time before 2017, 18 and 19. And I say that because that is, of course, the period over which it is agreed that the officer first of all became involved in a relationship with Miss P, and also the period, perhaps more importantly, over which it went so badly wrong, which I think we can all agree it did. They speak almost in the same words, despite being written by different people, of an officer who was, I don't think I overstate it by saying, a model police officer. Certainly one of the referees, I forget exactly who, but you do have them before you, speak of him as an officer who in fact defines an officer who would adhere to the code of ethics at all times, who could be relied upon, and whose honesty and integrity, whose credibility could be relied upon universally. And so I'd ask you to take that as a start point, because that is the type of person that you are assessing. And as I say, it doesn't come from simply one source. It comes from a number of different officers who worked with P.C. Birkinshaw over the years and worked in close proximity with him. But it also comes not only from officers who worked with him. You also have character references, in particular from Councillor Holmes, from those who know him well over the years, and who again speak universally as to his enthusiasm, his hard work, but perhaps more importantly in the context of this case, his honesty, his reliability, and the fact that he has always maintained the highest standards of integrity over the years. So, sir, in my submission, that is, as it were, a start point. That is the type of person that you are dealing with. What's then clear is, in my submission, to look at the agreed fact, to see what was occurring at the time that the conversation was had with P.C. Barker. And so that's important, perhaps, in this regard. we know that from around the April of 2018 through to the October of 2018, there was a very serious difficulty within the officer's personal life, which clearly had a very profound effect upon him. The relationship that he was in broke down between the April of that year and October. And so you will have noted clearly from the very fair opening line of the friend that in October of 2018, that had such a profound effect upon the officer that that was an issue that quite likely, if I am to expand upon it, we should perhaps move into private. I am certain that you will be aware of the incident of which I speak. So, sir, that we know that by October of 2018, the officer was experiencing severe difficulty. He, of course, then was off work until the April of 2019. And we know that, of course, from the reference supplied by Impeccable. Not only does she speak of him in very high regard as to his work currently, but she also gives you the information that it wasn't until April of 2019 that the officer was able to return to work. So in other words, we're talking about a protracted period. During it would be fair to observe that the officer was not dealing with things in the way that he would have done prior to October 2018. And so it's within that period, of course, that a number of other things, not related, in fact, yes, related to, but a number of professional difficulties became down for him to deal with as well. And that was, of course, May of 2019, he was served with the Regulation 15 papers. As they are, of course, relevant because they provide the background to how it came to be that there was an investigation. And it perhaps also must be borne in mind that those allegations, of course, you know, were not proceeded. And in that regard, perhaps that's important to note because one can only imagine the effect that that would have had upon the officer at that stage, given that he was already dealing with. And so, sir, moving to the key dates of that meeting with PC Barker, one knows that by that time he was at a stage where within a matter of days he was to attend court in order to secure that non-molestation order. It's right to say that, of course, no findings of fact were made because it was an ex parte application. It's also right, perhaps, to observe that had any issue been taken, that it was open to the other party to challenge that. It doesn't appear that that was done. But in any event, the terms of that order, regardless of whether there were findings of fact or otherwise, perhaps are indicative of the type of difficulties the officer certainly believed that he was facing and dealing with at around the same time, of course, that he was dealing with the investigation that led to this hearing. And it was in that context, of course, that he came to meet PC Barker in early May of 2019. And so I'd say that it is not the case that I suggest that any difficulty that was being encountered would have caused the officer to behave in a way that was dishonest. That clearly wouldn't be right, and I don't suggest that. There are occasions, of course, when that sort of difficulty would cause somebody to behave in a certain way. We're not into that territory. But I think it's right to observe that, of course, it does form part of perhaps the very important background to how the officer was coping and dealing with things at the time. And he turned to PC Barker. I think it's been suggested that the officer suggested in his responses that his visit to her was entirely for her own welfare. That perhaps isn't quite what the response. You would see at page 12, I think. At the time, he was devastated and distressed. He was extremely upset and tearful. This is at page 13. Decided to go to his friend who was also off work. But of course, it can't be right to suggest that that was purely a welfare benefit or welfare visit for her benefit, because the officer clearly says that he himself was very upset and fearful at that time and on that day. So it would seem that the import of that is, of course, that it was a two-way beneficial thing. And it's right to say that they were friends, nothing to suggest that they weren't. And so perhaps moving on from that, there, of course, I don't think it's that there would be anything inherently wrong in going to find about difficulties that you were experiencing at the time. In fact, it would be expected. One looks for support from his colleagues. One is in a difficult situation. So the visit and the discussion itself, in my per se. Of course, what can be criticised is what then passed between the two of them. It's right, the officer accepts the conversation that he had with PC Barker. Doesn't say that it didn't take place. But what he does say, and said quite clearly, again, I'm looking at pages 12, 13 and 14 in the officer's response. What he says was that his concern at that day was certainly not for himself. And so you may feel that has some force because, of course, the investigation into him had already begun. And the evidence in respect of that investigation would not, on the face of it, depend upon a photograph. It would depend upon the allegation that had been made by that third party. That was the cause and the evidence in that investigation. So when he says that his primary focus was the welfare of Sergeant Piggins, somebody who he had worked with, trusted and respected over the course of a number of years, and somebody who he viewed coming towards the end of his career was also facing his own difficulties at the time. His concern was entirely to ensure that Sergeant Piggins was not into something that would cause him distress and that. But so what the officer is clearly saying is that his focus in that conversation with PC Barker was the welfare of Sergeant Piggin. It was nothing to do with the investigation into himself, which was something that had already begun and had already started to take shape. Of course, the allegations had been made, they were clear, and this clearly came from Miss P. So perhaps further consideration may well be this. The evidence of intention put forward by the appropriate authority comes from PC Barker and that conversation. And the AA's case, quite likely, is that one can infer from that conversation that the intention was to derail an investigation into the officer himself. So if that was right, you may feel that it was something of a ham-fisted and poor attempt at. Because if one is turning to a friend that one trusts to assist with derailing or disrupting an investigation into yourself by effectively nobbling a witness, that is, I apologise for the colloquial nature of that phrase, but that is in effect what's being alleged. One might have perhaps expected a far more direct reference to that to be made to PC Barker. In other words, if the officer trusted her to the extent that he would ask her to do that, then one might expect that he would say, ask him to delete this so that people cannot get hold of it. Ask him not to speak to PSC or to deny it ever happened. In other words, you may feel that if his intention was to disrupt the investigation into himself, as is a, he would have been far more clear about that, and would have been put into effect, and what his intention was, what that was designed to achieve, why. So it's in my submission, it's very telling that not a great deal was said to PC Barker other than contact him face to face, tell him to delete the photograph. It's not an edifying way to behave, and of course the officer does accept that. It is an error of judgment. It's something he should not have done during the course of an investigation into himself. But the question isn't really in this case whether it was an error of judgment, poorly timed, poorly phrased, but the question is whether he did it with that intention to derail what was happening to himself. And so you may feel that given what you know of the officer, given his behaviour over the course of a number of years whilst in the job in undoubtedly difficult situations, and given that which he was undergoing and the pressures that he was under at the time, that what he said was the intention of looking after P.S. Piggin's welfare, as opposed to with any intention to do anything in relation to an investigation into himself. And so again, I would perhaps pray and aid the fact that the allegation that had been made has not been pursued. So, of course, the officer has not given evidence. That is something that, of course, as my learned friend rightly pointed out, you can take into account. But, of course, in this case, I would urge you not to, for the following reasons. Firstly, the facts are agreed. There is no dispute. Intention is the only outstanding feature of this case, and the officer has set out really quite bluntly what his intention was at 12, 13 and 14. So perhaps furthermore, it is right to say that the references that you have do speak to ongoing difficulties that the officer has, understandably, and the effect that these proceedings have had on him. And you may feel it's therefore perhaps no surprise that he said, I've set out my position, please make the decision. So in these particular circumstances, it would be my submission that having set out his position so clearly and frankly, actually, at pages 12, 13 and 14, that to hold it against him that he's not simply repeated that, particularly in the circumstances in on a personal level, should not be held against him. The assessment, therefore, as to what such conduct would amount to is really determined in my submission by your answer to that first question, what his intention was. Being very blunt about it, I think I would be being wholly unrealistic were I to suggest that a finding of deliberate dishonesty would not result in a following finding that amounts to gross misconduct. It is hard to imagine circumstances in which deliberate dishonesty would not amount to that. But it's not.
Sorry, you're breaking up a little bit. We can hear you, but you are breaking up just a little.
My apologies. I should have fairly secure Wi-Fi here. If it is, am I coming through clearly now?
That's better. Yes.
Excellent. So if it does go off again, could you let me know? I don't think there's a great deal I can do. I just have to wait until Wi-Fi improves, signal improves, yes.
Thank you.
If there was a finding of deliberate dishonesty, then it would, I accept, be almost inevitable that there would be a finding of gross misconduct to follow that. But there are, of course, any number of degrees in between that. The standard alleged is honesty and integrity, and of course the two are separate concepts. And it would be my submission that the officer, there is not the evidence there sufficient from PC Barker to infer that the officer's intention was to deliberately derail the proceedings into himself. He was acting with a lack of integrity is perhaps a slightly more difficult question, because that is a very broad concept. I think the Code of Ethics described this as doing the right thing. Now, on one view, any breach of the standards, any of the standards, would therefore or could therefore amount to involving a lack of integrity, because by definition, if one is in breach of any of the standards, one is not acting in a way that is doing the right thing necessarily. But so, as I understand the case of the appropriate authority, and I stand to be corrected, the suggestion is that the lack of integrity here would again be very close to acting in a dishonest manner. So, in other words, deliberately behaving in a way that would derail or undermine that, or could derail the investigation. And in my submission, the evidence in respect of that is the same as that in respect of dishonesty, and that what the officer did in speaking to PC Barker at all about asking Sergeant Piggin to do photographs was an error of judgment and would amount to discreditable conduct. That he's accepted, because of course, whether he was thinking about it or not, it may have been, there wasn't, in fact, an investigation to Sergeant Piggin at all. Nothing of that nature ever occurred. But of course, it has to be right, and it is accepted by the officer, that to ask somebody to do that would not be the correct thing to do. But in my submission, that would fall something short of acting with a lack of integrity that would come close to dishonesty. In other words, it would be an error of judgment, but one that would amount to the discreditable conduct standard and nothing more. And so if that was your finding, given the circumstances at the time, and given all that you know about the officer, in that regard, it would amount to a finding of misconduct, but not gross misconduct. But I fear that were I to say anything further, I would be going over old territory and merely repeating myself. The evidence in this case is brief. The papers are only 13 pages long. The issue is quite a narrow one. So those are my submissions on behalf of the office, unless, of course, there is anything you would ask me to specifically address you on. Okay.
Thank you. Ms. Fisher, is there anything that you want clarification upon?
No, I have no questions at this stage. Thank you.
Thank you. PCC?
No, I think it's very clear. Thank you.
Thank you, Ms. Barlow. We will now retire to consider our findings and to go through everything we've heard and have read and will be reading again. Not entirely sure at this point how long that will take us, but we will give you an update. It's now 15:50 or thereabouts. We'll give you all an update, hopefully through ESD at around about 4:30 as to how far we've progressed.
So thank you.
Thank you all.
Thank you, sir.
Thank you. Is everybody?
Yeah, we're all ready. I can run now. So I'll just double check we've got the right people. We've got 9 participants. So we've got the officer, we've got the Fed Rep, we've got Mike, we've got us, we've got Leslie, and then we've got guest. So hopefully one of the guests down there is but we need to double check we've got Sarah on. I think we have.
Ma'am, can I just say on Group 1 we don't have Mr. Rathmel and we don't have Sarah Barlow yet.
Okay, thank you, Leslie. We'll just wait until they arrive and back into Group 1. We'll just turn our speaker off for now.
Okay, thank you.
Thank you. There you are.
Thank you. Ms. Barlow, have you rejoined us?
Sir, I have. Apologies. I wasn't aware until just now that we'd restarted, but no, thank you.
Thank you. PC Birkinshaw, have you rejoined us?
Yes.
Thank you. The time is now 16:37, I think it is, and the hearing is resumed, including the audio. We have had the time to complete our deliberations in respect of the allegations set out at 6 and 7 in the Regulation 21. We do find the allegations set out at paragraph 6 and 7 proven to the requisite standard, that is, upon a balance of probabilities. We also find that the standards in relation to honesty and integrity and discreditable conduct have both been breached, and we consider that the conduct is gross misconduct as proven, that is conduct so serious as to warrant dismissal as being justified. Mr. Rathmel, could you please relate to us any information in relation to PC Birkinshaw's police service record? Mr. Rathmel, we can't hear you.
I getting on in the afternoon, forgot to take the mute button off, so apologies. But it might be best if the hearings administrator at headquarters there provide you with the personal record of service of the officer. That's something to which you must have regard in your deliberations. You'll see that the officer does not have previous findings of misconduct against him. So there's certainly no bad character submission from me on that basis. I would make submissions on the appropriate outcome. I can probably do so in less than 5 minutes, sir, because you have my written submissions. But it's just a matter of when you want to receive them. Would you like to hear them now?
I think we'd like to hear from you first, and then that presents Ms. Barlow with full knowledge in terms of the ability to mitigate, personal mitigation and character references, and anything she may want to take issue with that you wish to say to us. Thank you.
Thank you, sir. And I think that Ms. Barlow has, and I think the officer has had sight of the personal record, so I don't make any further submissions in relation to that. So briefly, I'm going to just refer you to the written submissions from paragraph 24 onwards in my opening note. It might help to have them there. The College of Policing's guidance on outcomes makes clear the three-stage structured approach to reaching the appropriate outcome or sanction in disciplinary proceedings. Firstly, to assess seriousness. Second, to keep in mind the purpose of imposing sanctions. And third, choose the sanction which most appropriately meets the purpose of misconduct proceedings, taking into account the seriousness of the conduct in question. That first stage, assessing seriousness, can be further broken down into the subcategories. that they do overlap to a certain extent, but if possible, where possible, take this staged approach, consider when assessing seriousness, culpability, harm, and then aggravating and mitigating factors. And when I come on to mitigating factors, I'll just address briefly the case of Nauls, N-A-U-L-L-S, which my learned friend Ms. Barlow mentioned in her submissions. Very briefly, in relation to culpability, the officer has, to put it bluntly, no one to blame for his misconduct but himself. This isn't a case where two officers working together responded to a situation poorly. This is a case where the officer made his choices and he did so by himself. Overlapping to some extent with that is the assessment of harm. Again, briefly, the harm is to PC Barker because she was asked to do something improper, which to some degree distressed her. The harm is to the reputation of the West Yorkshire force and the police service generally, because public confidence is engaged. But even if we couldn't be so specific about those harm elements in this case, I'd refer you to paragraph 4.60 of the College of Policing's outcome guidance. Which states that the panel should consider how such behaviour would or has been perceived by the public, which is relevant, irrespective of whether the behaviour was known about at the time. So, to paraphrase, it doesn't matter whether this case is national news or local news or not. It's what would reasonable members of the public think about this case if they were informed. What impact might that have on public confidence in the police service, in particular this officer's integrity and honesty in connection with investigations. In terms of aggravating features of this case, the panel's just reached its decision, having just considered all the evidence in the case, so the panel knows where its mind is at best. I simply note that this is a case of, to some extent, premeditated wrongdoing, not for days or weeks, but for hours, because the officer received an investigation notice, made the decision to make contact with PC Barker, drove to her house, discussed the investigation with her, and asked her to do something which was grossly inappropriate. This is not a heat of the moment case or a case of misspeaking. A second aggravating factor the panel might think is the reference in the guidance on outcomes to interfering with evidence or concealment of misconduct. What's the nature of this conduct? The officer sought to put out a message to a potential witness or interested party in an investigation, and he tried to do so through a trusted back channel, being PC Barker. So there is that element of concealment there, and there's also the element of interfering with evidence, the potential witness evidence of Sergeant Piggin, but also the photograph. Of course, the photograph was relevant to an investigation about potentially wrongful disclosure of the photograph. Of course, investigators might be interested to see the photograph. What does the photograph tell them? It tells them nothing if it's been deleted. And thirdly, although I've touched on it already, is the aggravating factor of using, and this is really inherent in the conduct in any event, but using another officer to achieve what he wanted in relation to PC Piggin and the photograph, and that other officer is, of course, PC Barker. In relation to mitigation, the officer has the personal references, although they don't speak to the particular conduct which the panel has made findings about. And so the panel has to focus on mitigating circumstances as they relate to the conduct which the panel has found proven. How relevant is the officer's mental health history? Well, it was an ancient history. He had been away on leave between October 2018 and April 2019. but the misconduct in question happened approximately 2 months after his phased return to work, and the mental health history does not explain why the officer acted in the way that he did. There's certainly no medical evidence, and I don't understand the case to be put in this way, that the officer didn't have capacity or that he spoke because he was under the influence of a medical condition which caused the misconduct. And that might be a convenient time to refer to the case of Knowles. It can be, the judgment itself can be sent to the panel, sir, for you to consider. It's a case involving an appeal by the Commissioner of the Metropolitan Police against a finding in the Police Appeals Tribunal that a final written warning could be applied to an officer found guilty of a gross breach of the standard of honesty and integrity. So it's sometimes relied on as a case of what I paraphrase is the small residual category of cases, standing apart from Salter, where a finding of gross lack of honesty and integrity won't result in dismissal. It might result in a final written warning. So it's important you see that case. It involved an officer who lied about his reasons for being in the first class carriage when the British Transport Police came across him, and then the officer lied about lying, as he later admitted in full and demonstrated insight in relation to in misconduct proceedings. Again, a rare case of breach of honesty and integrity which didn't result in dismissal. For brevity, I'll give you the key paragraphs in what is a long judgment, which I suggest that the panel read, sir. They're paragraphs 1 to 3 inclusive, paragraphs 24, 31, 45, and 46. I should also mention, apologies, paragraphs 10 and 12. I won't read them out, but I invite the panel to read them. The submissions I make in relation to Knowles are as follows. Firstly, I think it was an Inspector Knowles had fully admitted his conduct and come to terms with it. Query whether PC Birkinshaw in the present case has really come to terms with his misconduct and demonstrated insight in relation to why it's so serious that what he said to PC Butcher in the context of investigation was gross misconduct, as he didn't admit, but the panel has now found. Secondly, Inspector Knowles lies that he was found guilty of the breach of honesty and integrity for started in a panic, whereas this is not really a case of panic. Thirdly, Inspector Knowles' personal circumstances were genuinely harrowing, as you'll see in the judgment, but also there was specific psychiatric evidence in that case from a medical expert who said that the inspector's thought processes were affected. So that explained why he had conducted himself as he had. There had been an objective breach of the standards. The panel made findings, declared that that was a gross breach of the standard of honesty and integrity, but it was specifically mitigated by reference to medical evidence which explained why the officer acted as he did. Whereas in the present case, PC Birkinshaw, whilst he does have some moving mitigation, did have the support of the force, was granted substantial leave when he needed it in relation to his health history, but there's no psychiatric evidence or even lesser evidence that medical history was operative in the sense of causing his misconduct. That's the subject of these proceedings. That's not the officer's case, as I understand it, but there's no evidence of causation in that respect in any event. So Knowles is an exceptional case with exceptionally clear evidence where a breach to the level of gross misconduct of the honesty and integrity standard won't result in dismissal, or at least the High Court's not going to overturn it as irrational. The present case is not such an example, and for the reasons I submitted in my written opening submissions, it's regrettably in the public interest that PC Birkinshaw be dismissed. I'm happy to assist the panel, sir, if there are any questions. Otherwise, I'll stop there.
You have any questions?
No.
Mr. Fisher, do you have any questions?
Sorry, just unmute. Sorry. No, I have no questions. Thank you.
Thank you. I don't have any questions, Mr. Rathman. Thank you. Mr. Barlow, if you could address us in relation to mitigation and sanctions. We can't hear you.
So I hope you can now.
Thank you.
Yeah. So I can do, and it perhaps wouldn't surprise you to know that, of course, my the thrust of my submission would be that this falls within that rare exception to the case of Salter. And of course, it's paragraph 5, really, that one is looking at when one is looking at the guidance on outcomes. So I am very conscious of one thing, of course, and that is that I haven't spoken to the officer at this stage. Ordinarily, of course, I would, because there are certain things that flow from, of course, your findings. I wonder whether I might have the opportunity.
Of course. We're in your hands. If you can give us an update when you consider it appropriate. Thank you.
Sir, of course I can. Thank you.
Thank you.
Have you got the email?
I don't actually, Ms. Barlow.
Oh.
I have it. It's come through to me.
Excellent. Thank you.
And now I've got it as well. Thanks.
Brilliant.
Yeah.
Ready?
Yes. Thank you. It's now 17:10. Thank you for rejoining us. Have you had sufficient time to speak to PC Birkinshaw?
Sir, I have. Yes, thank you for the time.
PC Birkinshaw, just to explain, at this point in time, we are now looking at your mitigation. We will reconsider, as well as part of that, obviously your service history and your character references. Your council will now address us also in relation to sanctions guidance, which has been produced by the College of Policing, and which is something we are obliged to take into account in determining issues related to potential outcome. If you have any further questions that you'd like to address with your council, please speak up, because this is an important point, obviously, for you in terms of the opportunity to fully present mitigation. Thank you, Ms. Barlow.
So thank you. So again, I will keep my submissions relatively brief. I don't think it will benefit anybody were I to rehearse the content of the sanctions guidance to any particular degree. I know that all parties are fully familiar with it. So could I say that, again, when it comes to the law, I take no issue with the submissions made by the appropriate authority. The approach to be taken is clear and clearly set out in the sanctions guidance. Firstly, the assessment of seriousness. Secondly, of course, having in mind the purpose of sanctions, And of course, that again refers back to cases such as Salter, dealing with, I appreciate, the reputation of the force and public perception. And of course, having considered those matters, one then decides the most appropriate sanction in the case, of course, before yourselves today. So could I deal briefly, if I might, with issues of aggravating factors? It's been obviously submitted on behalf of the appropriate authority that this was premeditated and planned. However, it's perhaps right to observe that given the circumstances of the meeting with PC Barker, it does appear that the meeting was initially for lunch and to speak about the investigation. Certainly, it seems that there wasn't any sort of structured conversation, and it would be my submission that this wasn't premeditated. It was more of a response, and a panicked response, to having been served with papers or the Regulation 15 notice. I mentioned the word panic because, of course, the officer's first reaction was to turn to a friend of his, and we are talking about in very close proximity to him having been served. There's no suggestion there was a delay or any premeditation that took, shall we say, days or weeks. So, however, perhaps the most pertinent part of the guidance, and so I know the part of the guidance that I'm sure you will be most concerned that I address you upon, is, as I've said, paragraph 5 that deals with the question of operational dishonesty. The guidance is, of course, drawn from the relevant authorities, and I take no issue with those. And of course, that guidance suggests at paragraph 5.3 that dismissal will be almost inevitable in cases where operational dishonesty has been found proven. There may be exceptions, but the number of cases will be small. And of course, where you conclude that a case involving operational dishonesty is exceptional, you must identify the features that make it so. I also accept, as I think I said in my last submission, that at this stage, personal mitigation can be taken into account, but I accept that it is of less weight at this stage for the reasons that were set out in both Bolton and Salter. So that said, I would seek to persuade you that this is an exceptional case. I do accept that whilst there is no psychiatric evidence before you, what there is clear reference to what must have been a very serious mental health issue. So you know from the agreed facts, I know they're not written down, but it is agreed as a fact that that required the hospitalisation of the officer in October of 2018. And that is, in my submission, really very proximate to the issues that we're dealing with. Whilst there was a phased return to work in April of 2019, of course, I would ask you in that regard to consider carefully the content of the character reference of Inspector Bairstow, who quite clearly refers to that being a phased return to work. It is not a case in which the officer was suddenly, as one might expect with that sort of difficulty, it simply does not disappear overnight. It requires, certainly following hospitalisation, treatment and addressing. So, sir, I think it would be reasonable of you to find that that issue was of such severity that it would have required treatment and hence the phased return as opposed to the immediate return to work. Perhaps what is equally as telling in respect of this being a case which I suggest would fall into the exceptional category is the personal mitigation of the officer, but in two respects. I say personal mitigation because, of course, it is personal mitigation in the sense of having people speak to his professionalism. and that was unquestioned. He was an exceptionally highly regarded officer, and so I would venture to suggest that it's perhaps rare that in proceedings such as this one would see quite such glowing references from such a number of senior officers. And of course, sir, that is supported by his service record. Again, I won't take you specifically to it. I know that you have it, but that entirely accords with the references that have been put forward on his behalf. And of course, those references are equally as important, not simply because of their exceptional nature, but also because they speak to the difficulties that the officer encountered in late 2018, early 2019. And certainly they speak to his struggle over that period with mental health issues. They are ongoing, as one might expect. And so it is for that reason that I refer to the case of Knowles, because of course, whilst the officer's situation is not identical to that of Inspector Knowles, one is never going to get situations that are identical, of course. But what that case does tell us is that it was not unreasonable to find that that was a case that would have fallen into the category of that small number of exceptional cases. And that was by reason of the inspector's mental health difficulties at the time. Now, so as I say, I realise there is no psychiatric report, but nevertheless, it is a clear case in which this officer did undoubtedly suffer mental health difficulties. And whilst I do not suggest that they caused him to be dishonest, that would be a step way too far. I don't think that was in fact ever suggested in the case of Inspector Knowles. It was mitigation for a situation as opposed to a cause of dishonesty. It would be very rare indeed were there to be a situation where a mental health issue would cause dishonesty. But nevertheless, in my submission, we are in a similar situation here, because clearly we have an officer with an impeccable service record, very highly thought of by both his superiors, his colleagues, and those who he comes into contact with as members of the public. He is clearly exceptionally highly thought of, and in that regard, to behave in this way as a result of what I suggest was clearly panic on the day is wholly unusual, and his mental health issues, in my submission, sir, must play a significant part in that. And so it's for that reason that I submit that this does fall into that very small, and I accept very small, category of case where dismissal is or can be avoided, because this is an exceptional case when one looks at that particular piece of behaviour. And of course, it is a single episode. It's certainly not something that the officer there's ever been a concern about in the past. And perhaps returning to my original submission to a degree, it was somewhat ham-fisted, and that perhaps speaks to the lack of premeditation and thought that went into it. So those would be my submissions on behalf of the officer. I don't know whether you would wish me to address any further points, but in my submission, the key in this case is whether or not it falls within the exceptional category.
Thank you, Ms. Barlow. Any questions?
I have no questions.
Mr. Fisher, have you any questions as a result of the address?
Thank you. I've got no questions.
Thank you both, and PC Burtonshaw. We will retire now to consider the appropriate outcome. We're not sure how long that will take us. We would hope to reach a decision in respect of that today. We will work our way through the sanctions guidance, all of the mitigation that's been presented, including the character evidence, the health issues, which have been referred to and the police record, and we will approach it on the basis of the methods set out in the guidance in terms of how we assess the appropriate outcome. Thank you all. We will return. I'm sure Officer Burtonshaw wants to know what the outcome is, and we'll do that as quickly as we reasonably can.
Thank you, sir.
Thank you.
Everyone's present, ma'am.
Thank you. It's now 18:07 and the hearing is resumed. PC Burtonshaw, I hope that you can hear us. We can't see you, but we can. We believe that you can hear us. Is that correct? PC Burtonshaw? Can we check that PC Burtonshaw can hear us?
Sir, I'll just email my solicitor.
Thank you.
I'm just going to check with him now.
Thank you. Now, I take it you're participating.
Yes, sir.
Thank you. PC Birkinshaw to be effective.
Apologies, I'm back with you.
Thank you. The hearing is now resumed. I think the audio recording has recommenced and it's 18:08. Thank you all for your patience. We've reached a decision in respect of these misconduct proceedings, and in reaching the decision in relation to the disciplinary outcome, we have given due consideration to all of the evidence which has been placed before us, all of the information which we have received. We've considered, PC Birkinshaw, your police record, evidence and mitigation presented on your behalf, character evidence. We've considered the information we've received in relation to your medical background, and the relationship breakup which was occurring. We've obviously also had to have regard to the nature of the allegations, the interests of the public, the interests of the police, and we've applied after some considerable discussion, the sanctions guidance, and worked our way through it in the suggested way. We have reached the conclusion that the conduct is gross misconduct, and that the only appropriate sanction is dismissal without notice. We cannot reach the conclusion that what occurred falls into the small residual category. We will, PC Birkinshaw, provide you with full reasons which you want to discuss with Ms. Barlow when you have the detail. Appreciate that you have had a long and difficult day and may not be in a position to take all of this in. I think it's appropriate that you have the information in writing so that you can consider it and consider whatever steps you may want to take in the light of the decision. Can I thank you all for your patience, cooperation, and assistance and help throughout. The time is now 18:11, and these proceedings are closed.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.